April 2022 by the Ilorin Division of the Court of Appeal. I'm now going to the merit of the case. That is, whether the claimant has proved his case to be entitled to the relief sought. Generally, the onus is on the claimant to prove that the termination of his employment is unlawful, null and void, and that he is entitled to the relief sought. And because he's the one seeking for, please mute your, you are hearing your conversation. Cannot mute yourself.
Council, my lord is directing that we should all mute our
Good morning, my lord.
Good morning.
Please, I cannot hear you, my lord. I cannot hear you. No, my lord.
My
lord, good morning. I was having network challenges. I can hear you now, my lord.
Good. And
my lord, I'm sorry to come in late. My network, I've been having network challenges over here.
And who are you, please? And because
Sharon J. Esquire for the first defendant, my lord. Yes, my lord.
Sharon.
Yes, my lord. Good morning.
We are not doing your case now.
Okay. My lord, they gave me 1 o'clock. I have two, my lord. 03 and 30.
I'm reading judgment now. Is your own
I'm
judgment?
very sorry, my lord. No, my lord. No, my lord.
Oh, okay.
I'm sorry, my lord. Thank you.
Yeah. And because he's the one seeking for judgment on the existence of certain asserted facts, the burden of proving those facts rests on him. In other words, he who asserts must prove. See the case of Buhari and Obasanjo, Bayelsa and Rivers, Ipegu and Nigeria, and these propositions are also the purport and tenure of section 131, 132, and 133 of the Evidence Act. There's also the requirement that the claimant must do so on the strength of his own case and not on the weakness of the defense, subject to some exception. In the case of AIC Limited and NMPC and Abimbola and Abata. This case is rooted on determination of employment dated 17 July 2020 to take effect immediately. The letter of termination itself did not state any reason, but from the pleadings and evidence of parties, the reason for the termination of employment is the negligence of duty by the claimant regarding the discovery of fraudulent transaction of 5.010 million on the 5th of December 2017. Since this is the actual reason for the termination of their employment, the law imposes on the defendant, that is employer, a duty to establish the reason to the satisfaction of this court. See the case of Shell and Onariwaju, and more particularly, the dictum of Chukwumeka Ene in the case of Institute of Health and Anyi. And I quote, although it is tried that an employer is not obliged to give any reason for firing his servant, all the same, it is settled law that where he has provided any reason at all, it is obliged to satisfactorily prove the same, as the onus is on him in that regard. Otherwise, the termination from dismissal may constitute a wrongful dismissal without more. End of quote. The defendant, having given negligence of duty in respect of the discovery of the fraudulent transaction as a reason, he is bound, the defendant is bound to submit the termination. This calls for the evaluation of the evidence adduced by the defendant vis-a-vis that of the claimant, and in so doing, reference to the argument of the parties will only be repeated where necessary. To this end, the defendant has given particulars of the claimant negligence as A, the claimant failed to carry out an investigation. B, he did not carry out the first line of investigation of the fraud, which he ought to have done as resident control officer. C, the defendant did not fully, adequately, and timely inform his supervisors about the fraud. At a point, the claimant, that is D, at a point, the claimant had secret meetings with one of the staff involved in the fraud, as the investigation report will show. The defendant is therefore bound to prove the particulars of negligence above, and in doing that, the defendant tendered Exhibit DW1 and DW2, that is internal audit and investigation, and the minutes of the disciplinary committee, respectively. The outcome and findings of the internal audit and investigation, that is Exhibit DW1 on the claimant, is as follows. He called for a saving withdrawal ticket with amount in words written as 20,000 naira, while amount in figures was stated as 1 million, with which 1 million was withdrawn from customer's account. The transaction was the subject of dispute as customer denied making such a withdrawal. Prior to absconding from work on the 09/12/19, Mbong Essien visited Chijioke Anizo at his residence by 4 a.m. on Friday, 6/12/19, where they reportedly had discussion for over 2 hours. He reportedly shares a coordinate relationship with Mbong, which may have impaired his control function. He is currently on suspension pending the outcome of his investigation. End of quote. On the other hand, the minutes of the disciplinary committee meeting recorded the summary of the interview with the claimant and just came out with a decision, and I quote, he was not diligent in his duty as a control officer and recommended his termination for gross negligence. The question is, can it be said that the defendant has established gross negligence against the claimant as regards the fraudulent transaction of 5.01 million on the 5th December 2017? Before answering this, recourse had to be made only to two aspects, two aspects of the claimant pleading and evidence. First is the discovery of the transaction itself by the claimant. It is in evidence, both in the pleadings and in evidence of the claimant in court, that he discovered the fraudulent transaction and promptly reported it to his supervisor, Musa Uchechukwu Ozovo, who directed him to issue query to those involved which he did as instructed. The defendant witness admitted this much under cross-examination. Second, it is equally in evidence that the EFCC investigated the level of involvement and liability of all the staff of the defendant in this fraud case and charged them to court. Exhibit CW7, which is the CTC of the charge sheet, clearly shows that the claimant was not charged to court in connection with this fraud. To start with, the first paragraph of Exhibit DW1 talked about the involvement of the claimant in the withdrawal of 1 million from customers' account and not the fraudulent transaction of 5 million, which is the reason for the termination. It is therefore obvious that Exhibit DW1 and 2 fell short of justifying the particulars of negligence enumerated by the claimant as they are currently contrary to the evidence adduced in this case. Even the confirmed meeting between the claimant and Obong Essien, one of the staff involved in the fraud, did not reveal anything to advance the involvement or negligence of the claimant in the crowd. I have therefore no hesitation in finding and holding that the determination of the employment on the account of negligence of duty is wrongful without more, in line with the case of Institute of Health and Ain. What is then the fate of the relief sought by the claimant in this case? Relief D is for the sum of 2.7 million, being the claimant 8-month salary from December 2019 to July 2020, with 25% monthly interest amounting to 633,000 until the total is liquidated. Having found that the determination of the claimant is wrongful, he is entitled to his salaries and other entitlements as computed by him. But the interest element cannot be granted for lack of entitlement. See the case of Court Surveilling and versus Margin Market Telecoms Services Limited, Omenike David Vian and Deep Capital Market Trust Limited. Having held determination of employment is wrongful, it goes without saying that the claimant is entitled to some measure of damages. See the case of Do Solar and Nigeria Gas per KB Akas, Justice of the Supreme Court. The question is, in what quantum? Can it be the sum of 25 million being general damages claimed by the claimant in relief J? The nature of damages recoverable in employment is always a naughty one. Damages recoverable in employment cases have the damages recoverable in employment cases have been well pronounced upon by our courts in several decided cases. Such damages are said to be the losses reasonably foreseeable by the parties, Shana and Afropac. The measure of such damages is the salary for the length of time for which notice of termination ought to have been given in accordance with the terms of the contract of employment or agreement between the parties and other entitlements due to him. Damages claim needed not to be specifically pleaded, but arises from inference of law and provable by evidence, that is Union Bank and Chimanzi. The fact that the damages are difficult to assess does not disentitle a party to compensation from a breach of contract, or the fact that the amount of such loss cannot be precisely ascertained does not deprive the party either. This is Marine Management and NMA Mahmoud Mohammed, Justice of the Supreme Court, as he then was. The case of Sahara Energy Resources and Oyebola, however, represented a paragon shift from this harsh common law rule in employment cases. In that case, my Lord Ogochukwu Anthony Ogbag, Justice of the Court of Appeal, interpreted and applied the provision of Section 254C1F of the 1999 Constitution as amended. In the Third Alteration Act and Section 7(6) of the National Industrial Code Act 2006, regarding international best practices. Based on this new visa, I'm inclined to award the claimant damages in the sum of 8.2 million, being the claimant's salary for 2 years as damages. The justice of the case demands no less. The order for reinstatement, on the other hand, must fail. The reason is simple. The law is that where there is purported termination of contract of service, as in this one, order of reinstatement is rarely given. Termination of contract of service, even if unlawful, brings to an end the relationship of the employer-employee. The law is tried that a servant, even though willing, cannot be imposed on an unwilling master. A declaration that the termination of employment is null and void and of no effect only affects contract of service with statutory flavor, where the statutory preconditions have not been complied with. See the case of Tukuma and Shell, Itafa and Shell Petroleum, Edirima and River State, Cambo Metal Nigeria Limited and Activate, then Dosola and Nigeria Gas Limited. The claim of 158,000 in Release E, being claimant's share of profit for the year 2019, cannot be granted. Being a monetary claim, the claimant has the burden. The claimant has burden to establish his entitlement to the claim and the quantum of his claim in terms of how he came about it. This is Oyo State and Alhaji Apapa, Mohammed Dungus and EL Consortium Limited. In other words, it is the duty of the claimant to plead only such facts and materials as are necessary to sustain the relief sought and adduce evidence to prove same. None of this happened in this case. Similarly, an order to pay the sum of 1.7 million as compensation for claimant's Toyota Camry damage in the premises of the defendant on the 21st day of October 2019 cannot be granted. This is simply because the duty of care and the liability of the defendant in the accident leading to the damage of the car are not established. The police report on the accident, that is Exhibit CW8, and the photographs of the car and the claimant fence Exhibit CW3 is in no way fix the duty of care, as in no way, sorry. Fix the duty of care and liability for the accident on the defendant. If anything, Exhibit C has identified the truck driver responsible for the accident, which also damaged some properties of the defendant. See generally the cases of Diamond Bank and Partnership, Hamza and Kure, Leventis and Akpo, Abubakar and Joseph. Even the case of Anya and Concord Concord Hotel cited by the claimant does not support his claim. As for relief F, G, and H, for the statement of account of contributory pension, annual tax clearance certificate, National Housing Fund, respectively, the release are of no moment in the absence of any direct allegation against the defendant that the deductions were not met. I'm left with the claim of 2 million naira as cost incurred in prosecuting this case. That is relief F. On the authority of SPDC and Okenedo, the claimant cannot force his cause of litigation on the defendant in the absence of any express agreement to that effect. In any event, a claim for legal fees is akin to special damages, which must be specifically pleaded and proved, and this is not done here. For the avoidance of doubt, it is hereby declared that the purported termination of the employment of the claimant is wrongful in law. The defendant is hereby therefore ordered to pay the claimant as follows. 1, the sum of 2.7 million being 8 months' salaries from December 2019 to 2020. The sum of 8.2 million being the claimant's salary for 2 years as damages. All payments to be effected within 30 days from today. I make no orders to cause. Judgment entered accordingly.
As a court pleases. We are most grateful, my lord.
You are welcome. How do you mean what you are saying?
My Lord, respectfully, the claimant is also grateful for the judge. My Lord, we are sorry for coming in late. I am E. Philip, my Lord. Thank you, my Lord. My Lord, respectfully, the claimant is grateful for the well-considered judgment. I am E. Philip for the claimant. Lord.
Mrs. Okon, call the case again.
Okay, my lord.
Case number 1, right?
Yes, my lord. Case number 1.
Which one? UI.
47, my lord. That was the one that you've given judgment. Okay, number 1, UI 30. Okay. Suit number NICN UI 30 2016 between Mr. Okokon Eto Antra and
let us sort ourselves here. It seems as if your cost list is different from our own here.
My lord is the same thing.
Give us.
Yes, now that number 7, that number 6 was for judgment. That was why I called it first.
Our own here is number 6, but let them call it by UI 30 2016.
Okay, all right.
Can tell this one.
Okay. Suit number UI 30 2016 between Mr. Okokon Eto Antra and 36 others and Attorney General Akwa Ibom State, Head of Civil Service Akwa Ibom State. My lord, parties are absent in court.
Appearance. Appearance.
May it please this honorable court to hear Ekemini Okoiso. My appearance is for the claimants. I sincerely apologize for their absence.
Yes. Yes.
Okay,
Yes.
Milord, in the absence of any appearance for the defendants, Milord, the matter was adjourned.
The matter was adjourned. The matter
for adoption of terms of settlement, Milord. Unfortunately, he said terms of settlement are not before the courts due to the fact that the defendants are yet to. They say terms of settlement, my lord, are not before the courts.
Yes. Yes. Yes.
As a result of the fact that the defendants are yet to sign the said terms. In the circumstance, my lord, we will be asking for an adjournment. May we respectfully apply that this case is adjourned to the 20th day of May, 2024, my lord.
To adjourn to
20 of May 2024, my lord.
Okay. Case is hereby adjourned 20th May 2024 for report of settlement. Defendants to be served hearing notice.
As the court
As four places.
As the court. Very grateful, my lord.
Call the next case.
All right, my lord. Case number NICN UY03 2019. between Mrs. Arif Okonokwon and the government of Akwa Ibom State, Agnes Uwe Okwon, alias Mrs. Arif Okonokwon. Ballot parties are absent in court.
I'm not even ready. What is it now? They called the case, you did not give me any file. What? Right. Yes, you said parties are absent.
Yes, my lord, but my lord, we have a medical report here of the claimants. That she is very ill. She's in the hospital. That's why she's not here in court.
Okay. Appearance.
If it pleases me, Lord, I appear for the claimants in this case. A.M. Aziz, my name.
Yes.
With profound humility, my Lord, Sharon J. Esquire. My Lord, my humble appearance is for the first defendant.
Or the first defendant only.
Yes, my Lord.
Any other appearance?
My Lord, my learned friend Kingsley Akaiso Esquire usually appears for the second defendant, like he has not joined the virtual proceedings today.
You said he used to appear for
the second defendant.
The second defendant.
Second defendant, my Lord.
Yes.
My Lord, when last we were before you, the defendants were not represented, and to state we are yet to be served with their final written addresses in this suit. The matter was adjourned at their instance till today.
Yes.
Yes, my Lord, with profound humility, we have filed our final written address and we have an application to regularize it. I'm so sorry we have not been able to serve any of the parties, but my Lord will sure do that after this sitting. I sincerely apologize for that. Yes, my Lord.
You want to regularize now?
Yes, my Lord. If the claimant's party, counsel is not opposing because it's a very harmless application, I can regularize and then serve him the final written address so that in the next adjourned dates we can move on, my Lord.
Why not? But
Thank you, my Lord.
My Lord, I have not been served with any application, so I cannot take any stand on an application I have not seen, whether it is harmless or not. I have not been served with any application.
Is it not to regularize?
It's just for regularize. It's a motion for extension of time so that we can make progress.
You just confirm they have not filed any final written address up to now.
Lord, we've not been served with any process at all.
Yes, I agree. I agree with the claimants. We've not served him yet, but after this sitting, my Lord will so serve him. I humbly apologize for that. But
No,
it's just motion to.
Talking to Aziz.
Okay,
You are
I'm sorry,
complaining they have not filed final written address. Now they want to regularize. You say you don't want.
Lord, we are not saying they shouldn't regularize. We have not been served with any copy of the motion for regularization.
So what do you want? You want another date?
Yeah, Lord, we should be served. Should be served.
I ask you, do you want another date?
Yes, my Lord. We want to see the processes filed.
So can you give me a date, the two of you?
Very well, my Lord.
Senior, so when do we come back?
When will you be able to serve me, Sharon?
They can serve you today because it's ready. So when do we come back?
Come back at the
first week of what?
Of April. When is court going on Easter vacation?
No. Let's go to May. Can we come back in May?
May is too far. May is too far for written address. No,
I don't have the dates in April, and April is a half month because of the Easter break.
I'll advise you, liaise with the registry to give you a date.
As a call, pleases.
Are you listening?
Yes, Madam. Why don't we give them 20th May? The same date.
20th May is okay.
Okay by you?
Yes, my Lord, it's okay. Ms. Okon, the permanent secretary's case, has it been called?
Yes, it has been adjourned to 20th May.
Okay, because I was having network issues. My system has been going off and off, on and off.
Yes, it's hereby adjourned to 20th May 2024 for adoption.
As a call, please.
As a call, please. My Lord, we are grateful.
You're welcome. What is the next one?
My Lord, the next one is 27.
Good afternoon. It's very wonderful.
Yes.
Suit number NICN UY 27 2020 between Mr. Effiong Sunday Akmanimowo and Federal Inland Revenue Service. My lord, parties are absent in court.
Appearance. Appearance.
This Hosanna.
Appearance.
My lord, in the absence of counsel for the claimants, my name is MT Ibrahim, and my appearance is for the defendants.
The Lord, very respectfully, the Lord, I'm sorry. Hosanna Robert respectfully appear for the claimant. The Lord, Hosanna Robert appears for the claimant.
I've taken note.
Thank you, my Lord.
Yes. Yes.
My lord, sir, on the 19th day of October 2023, this honorable court, upon the defendant closing its case, adjourned the matter for adoption of final written addresses to the 6th day of December 2023. My lord, unfortunately, we could not file, the defendant could not file its final written address until that 6th day of December 2023. My lord, consequence upon that, the defendant filed a motion on notice on the 15th day of March 2024. My lord, the motion is seeking for orders to regularize the final written address of the defendants earlier filed.
Did you serve the other party?
Yes, sir. We have served my learned friend for the claimants, and we have paid the penalty assessed by the registry of this honorable court, sir.
So can you move your motion?
For late filing.
Can you move
Very
your
well,
motion?
sir. Very well, sir. My lord, the motion is brought pursuant to Order 57, Rule 4.
Filed when?
My lord, was filed on the 15th day of March, 15 March 2024.
Yes, pursuant to.
It is brought pursuant to Order 57, Rule 4.
Yes.
Of the civil procedure rules of these honorable courts.
Yes.
My lord, our first prayer is for an order of this honorable court extending time within which the defendant applicant may file our final written address. An order of this honorable court extending time within which the defendant applicant may file our final written address.
Yes, second.
My lord, the second prayer is for an order of this honorable court deeming as properly filed and served. Deeming as properly filed and served. The said process. Requisite fees having been paid.
Yes.
And my lord, and for such order or other orders as this honorable court may deem fit to make in the circumstance of this case.
No.
My Lord, sir, in support of the application is an 8-paragraph affidavit. In support of the application is an 8-paragraph affidavit deposed by Edikan Michael Udoka, a secretary, office assistant in the office of the Claimants Council. My Lord, we also file along with the application a written address, and we adopt same as our arguments in respect of this application and urge my Lord most respectfully to grant same. Particularly, sir, as there is no counter affidavit from the opposing counsel against this application. Thank you, my Lord. We so move, sir.
Mr. Ibrahim.
Yes, my Lord.
I lost you when you.
Sorry, my Lord.
I lost you when you gave us the last prayer, the omnibus prayer.
Oh, okay, my Lord. My Lord, I said in support of the application is an affidavit of 8 paragraphs. Thank you, my Lord.
Affidavit of 8 paragraphs.
Yes, my Lord. Deposed by the office assistant in the law firm of the defendant solicitors.
Okay.
Yes, sir. My Lord, we also file along with the application a written address.
Yes.
My Lord, while we rely on all the paragraphs of the affidavits, we equally adopt the written address as our arguments in this application. And urge my Lord most respectfully to grant same. My Lord, my learned friend has been magnanimous enough not to oppose this application. There is no counter before the honorable courts. I will so urge the court to urge my Lord to grant the application, sir. Thank you, my Lord.
Mr. Robert.
My Lord, very respectfully. My Lord, we are not opposing the application.
Application for extension of time is hereby granted as read.
As the court pleases.
As the God pleases.
Yes.
My Lord, sir, this morning we received the. Hello, my Lord, sir.
Is Ibrahim talking?
Don't know if my Lord is hearing.
Is hearing.
Yes. Yes.
Yes, my Lord. My Lord, this thing we were served with the defendant's final written address.
This is Hosanna talking. Robert.
No,
my Lord, this is still empty Ibrahim talking, sir.
Yes. You said this morning.
My Lord, we have gone through the address filed and served on us by my learned friend.
Are you saying you have served?
And we have that we react to
served and exchange the final written addresses?
Well, yes, we had filed our own before we filed the application that we brought. And today, this morning, we were served with my learned friend's final written address. And when we went through it, we discovered that it is highly imperative that we respond to it by way of reply, sir. Particularly as my learned friend has surreptitiously, with due respect to him, brought in an application in an address. My learned friend has filed an application within his address, seeking to amend one of the prayers in his complaints. So, my Lord, it is incumbent.
So, do the needful now.
Yes, my Lord, we will say, my Lord, in the circumstance, we will most respectfully, sir, ask for a date, sir, to enable us to react appropriately.
But put it in a nutshell so that I can record you.
Yes, sir. My Lord, upon being served with the defendant's final written address this morning, upon being served with the defendant's final written address this morning,
yes.
And my Lord, having gone through same, having read through same,
yes.
My Lord, we consider it highly imperative that the defendant should file a reply to same, sir, in view of the issues raised therein, issues of law. Consider it highly imperative that a reply should be filed thereto, especially in view of the issues of law
Yes.
raised in the address, my Lord. My Lord, in the circumstance, we'll be applying for a date to enable us to do so, sir. My learned friend has brought an application in an address. Very strange. I have never seen it in my 20-something years of practice.
It can be a new learning for you.
Sorry, sir.
I said it can be a new learning for you.
Yes, my Lord, we learn every day. That's why I need to go and look at the law. Maybe the law has changed.
So can you give me a date now?
Very well, my Lord. My Lord, may we be guided by the registry of the court, sir.
My Lord, on the 20th.
20th of when, ma?
20th of May. 20th of May.
That's my name. That's okay now.
My Lord, 20th of May is not free for me. My Lord, I'm engaged on that day. It's not convenient for me.
It's ritual.
What other date is convenient for you? Let's know.
Except if it can be fixed by 2.
It's going to be in the afternoon like this now.
As the God pleases.
It's not me Lord talking, it's empty Brian talking. So don't take it as the
I'm sorry, sir.
So you have to tell my Lord your position.
Yes, my Lord, if it will be by virtual, maybe by 2 o'clock, 2 p.m., it will be convenient for me. By then, I must have been through with another case.
Yeah, you know. Case is hereby adjourned to 20th May 2024 for adoption.
As the God pleases. Well, we are most grateful, sir.
You're welcome.
Thank you, my Lord.
Yes.
Case number NICN UY 35 2020 between Joseph Robert Bassey.
Present, my lord.
That is
Akwa Ibom State University. The registrar, Akwa Ibom State University. My lord, the claimant is present in court. Defendants are absent.
Lemon is in court.
Yes, my lord. Defendants are absent, my lord.
Presentation.
With profound respect, my name is Joseph Bassey, holding the brief of somebody for Esquire for the claimant.
You are?
My lord, my name is Joseph Bassey, holding the brief of somebody for Esquire for the claimant, my lord.
So you are wearing two caps?
As court places.
Samuel Ekpo.
Yes, my lord. Samuel Ekpo Esquire for the claimant.
Yes.
My lord.
No representation for defendants.
My lord, there is.
Who is he and why is he?
My lord is a Kemenudum back in history. Maybe that can hear.
He is not with us today.
My lord is there. He's muted.
He has muted himself now.
That's let him on me.
I can see him.
My lord, let me chat with him, let him on me.
He has muted himself.
Yes, my lord, I'm trying to chat with him so that he can admit. Okay, he has done that.
My lord, I have done that. May it please your lordship, a Kemenudim. My lord, I appear for the defendants.
Yes.
My lord, this matter was adjourned to today for adoption of addresses. My lord, I was served with the final address of the claimant on Thursday, and I am done with the reply. But as I speak, the reply is being filed in the registry of the court by my staff. I will be asking respectfully for a stand down for 30 minutes if it is convenient to the court so that we can have our reply and the motion for extension of time completely, filed so we can use it for the adoption, my lord. I'm sorry if...
Let me record you.
As a court places.
You said today is for adoption of final written addresses?
Yes, my lord. I also said that I was served with the final written address of the claimant on Thursday. My lord, my reply to the address is currently being processed at the registrar of the court by my staff. I most respectfully pray for a stand down for 30 minutes So enable me complete the filing and make use of SEM for the adoption. I apologize for the inconveniences.
Mr. Basi?
Yes, my lord. My lord, we will not be opposing to that application. But my lord, on the last adjourned date, being the 18th day of January 2024, this honorable court imposed a cost of 30,000 naira on the defendant. My lord, they have not paid. My lord, it is court order which must be obeyed.
Yes, my lord.
You had
Well,
him.
my lord,
I think the best thing is 20th May okay for you, the two of you.
Yes, my lord, it's okay for me.
Not you.
Okay.
Mr. Basi and Ikemeni.
my lord,
I'll give you 20th May so that you can pay. You can pay your blessing.
My lord, concerning the cost, I can pay Learning Council the cost today. I can issue a check to him today, and then he will cash it, my lord. I was thinking that we could be accommodated by a stand down. My lord, I also think that May 20th is very far. I say so respectfully, my lord.
Okay, give us a date. I'm not going to give stand down because I have, apart from this virtual hearing, some lawyers are also waiting for me here in Kano. So between the two of you, give me a short date.
Mr. Cole, my lord, we can come back this month if the diary of the court permits. Any day this month, my lord.
I've given you the option to fix a date with the other party.
My noble lord,
Yes.
25th day of March. Since my little friend says
I can't hear you.
We have suggested 25th day of March. 25th day of March.
We are going to be on Easter vacation.
Okay.
April, it's capital city.
But my lord, I do not know if we can return tomorrow or Wednesday.
Okay. Okay.
I'm not returning tomorrow or Wednesday. I have commitment here in Kano.
As the court pleases.
It's unfortunate. By 25th, we are going on Easter vacation to return on, is it 5th or thereabout, and the Salah holidays after that. Mrs. Okon.
Yes, my lord.
Check your diary and give them April now.
My lord.
If they can be accommodated.
My lord, we don't have date in April though.
Since it is for adoption, I don't know. My lord, we could just adopt in 5 minutes, any day in April. I'm so sorry. Any day in April, my lord. My lord, I will not adumbrate. I will just adopt. So 2 minutes is okay for me.
My lord, 29th of April.
If it's okay by them, why not? Mr. Basi.
Yes, my lord. My lord, it's okay for us, my lord.
I can't hear you.
My lord, 29th day of April is okay for us.
Okay.
My lord, it's okay for me in the afternoon, with due respect.
No problem.
It's also okay for me in the afternoon, my lord.
Case is hereby adjourned to 29 April 2024 for adoption.
Places. Thank you, my lord.
Next. Mrs. Okon, next.
Okay, my lord. Suit number NICN UY49 2020 between Mr. Gallant Basi Edet Eduno and Independent National Electoral Commission. My lord, parties are absent in court.
Appearance.
My lord with profound respect. My lord with profound respect.
Yes.
Here, Akpan. And my humble representation is for the claimants in this case.
You said you are.
And yet here, Akpan is my name, sir. My appearance is for the claimants in this case.
Yes. Yes.
My lord, there's no representation for the defendants.
Yes, Papan.
Yes, my lord, we were served with the final written address of the defendants filed on the 15th day of February 2024.
Filed
on the 15th day of February 2024.
Yes.
However, my lord, we are unable to file our final written address, that is the claimant's final written address, due to the ill health of counsel. My lord, I had a very serious accident that affected my health. So, my Lord, in a circumstance, I will be praying this honorable court for an adjournment, my Lord, to enable me react to the final written address of the defendants. My Lord, I am very sorry. It is not in our character to do this, but the accident was very serious, sir. My Lord, we suggest the 20th day of May, 2024, subject to the overriding convenience of the courts. Yes, my Lord.
I'm saying, do you have any date in mind?
Yes, my Lord, I suggest the 20th day of May, 2024. My Lord, for for adoption of final written addresses. My Lord, before then, we'll file and serve same on the defendants.
Case is hereby adjourned to 20th May 2024 for adoption. Defendants to be served hearing notice.
As the court places. My Lord, we are most grateful, sir.
You're welcome. Next.
Suit number NICN UY02 2022 between Elder Dr. Joseph O. Eliezer and Utai Lee Nigerian Limited. Lee Ping Ding. Other parties are absent in court.
Appearance.
May it please your lordship, Assam Jr. My lord, I appear for the claimants.
Yes.
Respectfully, sir, my name is O.R. Oniyeson. I humbly appear for the defense.
O.R.
O.R. Oniyeson. Oniyeson, sir, is O-N-I-Y-E-S-A-N. Y-E-S-A-N. Thank you, my lord.
For the defender.
Yes, my lord.
Okay. Yes.
Yes, my lord, the matter is for adoption of written addresses. My lord, we regret to say that we have yet to file our written address. My lord, the reason was
Okay, let me go out.
Hello, my lord.
You said you
Lord.
regret to say that you are yet to file your final written address.
Yes, my Lord, on health grounds, sir. My Lord, on health ground, I was seriously indisposed on health ground for some time. I thank God I'm recuperating.
Yeah.
My Lord, that unfortunately accounts for why we have yet to file a written address. But my Lord, I respectfully undertake to file and serve same on the plaintiff before the next adjournment date.
Assam.
Yes, my Lord.
Yes.
My Lord, I've just listened to my learned friend, even though he had not reached out to me to indicate his delay. Of course, there's not too much I can do since it's based on health grounds, the basis for his
So
delay.
in short, you are not opposing.
My Lord, I'm constrained not to oppose based on the reason adduced, Your Lordship.
So no objection.
No objection. Only that if Your Lordship can, if he can file and serve us before the quite a reasonable time before the next adjourn date, so that we can be able to adopt on the next adjourn date, Your Lordship. Because if he serves us before or just shortly before, we may not be able to do anything on the next adjourn date.
So no objection.
Lord, we undertake to serve the plaintiff by next week, sir.
But Lord, in that case, we don't have any objection, Your Lordship.
So can you give me a date? Yes. Mrs. Okon.
Yes, my Lord,
Give
on
them
the
since they are dilly-dallying, give them a date.
my Lord, 20th of May.
20th.
Yes, my Lord.
Is that okay by you? Is that okay?
My Lord, 20th of May is okay for me.
Okay. And you?
I beg you.
My Lord, I can't hear my Lord again. The network is so bad here.
Case is hereby adjourned to 20th May 2024 for adoption.
As the
As the
court,
court pleases.
Yes, Mrs. Okon.
yes, my Lord, that's all, my Lord, for today.
Okay. So, in the absence of any other business, I'm signing off. Bye-bye.
As the court
Bye-bye,
pleases.
Yeah.